Welcome to this session of the Justice Committee and our inquiry into the work of the County Court. Welcome to our witnesses, who I'll come to shortly. Some of you are familiar faces, some are not, and welcome. We just have to deal with our declarations of interest by the members. I'm a non-practising barrister, former consultant to a law firm.
I'm a barrister with a current practising certificate, but not undertaking any direct court work. I'm the former Solicitor General, former Chair of CAFCAS, former Chair of the National Child Safeguarding Practice Review Panel. My brother is Chair of the Prison Reform Trust, and I'm also advising ministers on family justice policy.
I'm a non-practising solicitor.
Thank you very much, and welcome back to the committee, Mr. Chair. It's good to see you again. Okay, well, perhaps I can start off with a general thought. Perhaps I can start with yourself, Dr. Byrom, and Natalie. Good to see you. And then we'll come around to the rest of the panel. Do people really understand, the importance and the significance of the work of the County Court?
No, thank you so much, Chair, and thanks for asking this question, because I think it's incredibly important before we proceed with this discussion to set out what's at stake here. Now, the County Court is often, and it has to be said rather dismissively, referred to as the part of the justice system that deals with high-volume, low-value problems. So things like civil money claims, debt, personal injury, medical negligence, housing and antisocial behaviour. But I would argue, and you will all know this from sitting in your constituency surgeries, that this description is wholly inaccurate. The issues that the County Court deals with day in, day out are high volume, high impact problems for the economy, for public trust and confidence in the system, and most importantly of all, for the people who experience them. Now, on the first point, Chair, at the risk of embarrassing you, you have powerfully articulated on more than one occasion the importance of the civil justice system and the County Court in particular to the local and national economy. And I couldn't put this better than you, so I'm not going to try to. But on the second, as suggested by the high volume descriptor, the civil justice system deals with more people than any other part of the justice system. And while criminal justice attracts all of the headlines, it's the experience of going to the County Court that is most likely to shape people's broader perceptions of our legal system. And this matters. It matters a great deal because we've got a large and robust body of research to indicate that people's experience of the fairness and efficiency of justice system processes when they encounter them shapes their trust and confidence in the law and legal system more broadly. And I cannot stress enough, we cannot be complacent about this. In 2024, a tracker poll published by YouGov found that less than half the population in England and Wales is confident in the judicial system. And finally, and most importantly, the County Court matters because the problems that it exists to resolve and the issues that it seeks to adjudicate are extremely consequential for the people who experience them, affecting lives and livelihoods. Now, I don't need to remind anyone around the table that we are in the midst of a cost of living crisis. More people than ever before are struggling to make ends meet. People are living paycheck to paycheck. Research from the Resolution Foundation tells us that fewer than half of working-age households have 3 months of income saved. And in Q4 of 2023, the value of the vast majority of money claims or claims for damages, whether for personal injury or otherwise, were worth less than £5,000. Now, those are amounts that might seem small to some people, but the fact is, for many families, arguably for most families, these are amounts that are too large to lose. And there's a great body of research that indicates how financial stress contributes to problems like mental health, suicidal ideation, all of those things. So those are some of the indirect consequences for health and well-being of the issues dealt with by the County Court. But there are direct consequences too, particularly in relation to housing. Our Bishak should be at school right now. The fact that he isn't, that he died in horrible circumstances just after his second birthday, is an indictment of issues with enforcement that have been described by the senior judiciary as the Achilles heel of the County Court system. Earlier this year, ITN reported on the number of children injured in inadequate temporary accommodation. 55 children have died since 2019, most of them under 1 year old. So yes, the County Court does deal in high volume cases, but the issues that it deals with are high impact, and the stakes, should the system continue to underperform in the way it is at present, could not be higher. That's why it deserves your attention, and that's why we're all here today.
Thank you, Natalie. And we've got your report that you published us, your senior research fellow, of course, at the Faculty of Laws at UCL, but you've republished with the Nuffield Foundation, haven't you? Where is my justice gone? Which is in March of this year, so you referred to that. Can I come to Matthew Maxwell-Scott? Mr. Maxwell-Scott, you're Executive Director of the Association of Community Support Organisations. From your perspective of your members as users of the system, what's your assessment? Does it get enough recognition? And what can be done to improve that, to make sure it gets more resource, perhaps, or more attention?
Absolutely. Thank you, Chair, and again, thank you to you and to all the committee for holding this inquiry. I think it's incredibly important. As Natalie has said, civil justice is a part of the justice system that just gets very little attention in public policy terms, in media terms, all the rest of it. But actually, to consumers, to our fellow citizens, it is the most likely place you're going to access the legal system and the courts. So last year, there were 1.7 million civil courts claims, which is below the peak, which is around 2.1 million in 2006, but 1.7 million people last year. In comparison, receipts in the magistrates' courts, which is where the vast majority of criminal cases are heard, were at 1.37 million in 2023. So there's a significant difference. The civil courts are where justice should be happening. The problem, and this is why the inquiry is being held, is that it's taking a very, very long time for cases to come before a judge. Compared to 2019, it takes 24.7 weeks longer for a fast-track or a multi-track claim to reach trial. That's half a year, an additional half a year in 5 years. Now, clearly the pandemic has had an impact on this, but we need to remember that during the pandemic, claims numbers actually fell precipitously. So what we are seeing is far longer delays in a system with far fewer claims in them. And that suggests administrative failure on a monumental scale. Now, to my members who represent consumers in the civil justice system, generally as claimants, but sometimes as defendants.
Can you give me a sense as to what sort of organisations they be? Just in broad
Absolutely.
terms,
So we have law firms, legal expenses insurers, charities, road safety bodies, medical reporting organisations, rehab firms, all the different people that you might use if you were making a claim or perhaps if you were defending a claim. For example, personal injury or monetary claims, those sorts of things. If in doubt, they're normally lawyers, but not all of them by any means. And obviously they, as a consumer, you can operate as a litigant in person, you can throw yourself on the mercy of the courts. Perhaps some of the encouragement of doing that is to blame for some of the problems we've got now because people understandably struggle with legal systems. So my members are the sorts of people who will support you through the process, help you to make the claim. And to them, obviously, they need claims to be successful in order to have a viable business. And if claims aren't coming to court, ultimately they're not being paid for their work, which means they won't invest in the system. They won't invest in training, in IT and all the rest of it, because they can't be guaranteed that they'll have a successful business at the end of it, which means people's access to justice suffers because they cannot get the support they need to go through the system. So there are some significant problems. I'm sure my colleagues here will bring attention to them, but huge delays in a system that actually is receiving a far lower volume of cases than it once did.
Thanks. Now, I'm going to come to Elizabeth next. Elizabeth Gallagher, you're representing the Personal Injuries Bar Association, and I know you're in practice.
That's right,
in Chambers yourself. Anything from your perspective as a PI, personal injury specialist?
Yes. Members of PIBA, as we call ourselves, represent both claimants and defendants in personal injury matters. So in terms of the significance and impact of the problems with the civil justice system, we're able to assist in understanding those from both perspectives. So in a personal injury context, claimants would be individuals for the most part, and defendants may be individuals, they may be companies, they may be local authorities, but generally behind all of those people or bodies is an insurance company. So we can also assist with kind of the business and commercial impact also of the lack of funding and the lack of resourcing, the fact really that the civil justice system just doesn't function effectively, we would say. And these are moments of great personal significance for the individuals involved. Again, in a personal injury context, we're talking about people who have suffered injuries. Maybe those injuries were short-lived, but they can be extremely significant, having a life-changing impact. And even in those cases where injury has resulted in death, our members may be representing bereaved families. So the stakes are really high for everybody who's involved in the civil justice system. And as barristers, we're really at the coalface in terms of how things are playing out on the ground, and we see a system that doesn't work effectively.
Thank you. And Emily Giles, you're a housing lawyer with the Hyde Group, so housing issues, possession matters.
Yes, and we're obviously Hyde as a large provider. We're a member of the G15, which represents the 15 of the largest housing associations. And prior to working in a housing association, I worked in local authority. Yeah. So I think the experience that our particular association suffers at the moment, it will be mirroring that felt by the other organisations. I think the fact that's sort of like missed is, and it goes back to the point that was made about the high impact, is that we're having to use the civil courts for our effective tenancy management, and a lot of that stems back to antisocial behaviour. Yes. And those can be possession proceedings, and those can also be injunction proceedings. And obviously the impact on delays to those kind of cases being litigated has severe consequences for our residents, for our estates and for our communities. And I'm sure members of the panel here in their constituency business will have been approached by persons who are feeling unhappy with how a matter is being dealt with. And very often it's a case that we will have been progressing a matter and we'll be engaging with the relevant statutory support agencies. We'll obviously be looking to the maxim of litigation should always be seen as the last resort, and then we will progress to that point when we actually have to bring a claim into the court, and then suddenly the brakes are slammed on and we find ourselves unable to progress matters in an effective and just way, and that can be very difficult to manage in terms of our communities. And we also find ourselves in situations where we're becoming increasingly worried that a really serious incident could occur, because we are trying to mitigate against, very awful and very often serious criminal and unlawful behaviour that's related to maybe organised crime, etc., and things like that. And it's preventing us from actually being able to, protect people and manage our stock effectively. Another point I'd like to make is that another function of a social housing provider is to perform the matter of housing people. So obviously we will have nomination agreements with local authorities. The delays in us being able to take possession action, regardless of what type of tenancy breach that is or renter is, means that we are losing, as a charity, a lot of income to the fact that there are these massive delays to us recovering our property back. So that will be lost income to increasing rent arrears. It will be lost income to use and occupation charges. It will be lost income because very often we would take a pragmatic approach and not pursue our costs, our legal costs against some of our defendants, because they're vulnerable persons. We're not going to see that money back, and it's not cost effective for us to then go down the route of pursuing that money. So as a charity, we are seeing increases in our costs and our expenditure, which is obviously putting huge pressures on the resources that we are trying to provide in a housing crisis.
Okay, thanks. And you set out, all of you, in your written submissions, I think, some of the particular details and the statistics of what you're seeing around these. This may seem a bit left field, but somebody's raised it with us. The county courts were set up in 1846. Does the name county court help or not, do you think? I'm not sure I can think of a better one, but does it cause a bit of confusion as to what on earth that is?
I wouldn't say it causes confusion. I don't think it necessarily explains what the court actually does. Yes. But I would probably say, on behalf of practitioners, we'd rather see real change than superficial name change.
That doesn't make much difference, does it? I think that's the general idea. It's got to be called something, hasn't it, at the end of the day. I think that's probably okay. Back to the point about delays, which is the things that I think all of you have referred to. I know, as a London MP, we seem to have, from all the statistics, there's a particular problem in London and the South East. Yes. And some other big urban areas, or not? Would you identify other parts? Or is it...
I think there's some quite good data in the evidence given by some of the people that shows it's a postcode lottery. Yeah. Now, obviously, there's bound to be an element of patchiness, but it's quite extensive. And London and the South East are very, very bad. There are some that are less bad. But it's that patchiness and the notion of a sort of local fiefdoms controlled by the judiciary that just seems to produce very different outcomes. And you will get some of the national firms who do cases nationally do have good data on that. And that is an issue. Definitely.
Because the geographic distinctions were abolished a while ago now, weren't they? It's actually it's a unified county court. You can issue anywhere, but there seem to be very great variations in terms of how long it takes. Natalie, what's your evidence on that?
I think, if I may, Chair, so there have been concerns that have been... So comparing regional performance and court-by-court performance is really difficult because of the way the statistics are currently presented. Yep. And there have been sort of concerns raised by some quarters that the data on delays is actually misleading. Now, I don't consider the data on delays to be misleading, but I do consider it to be incomplete. Full disclosure, I currently chair the data working group for the Civil Justice Council, although I'm speaking in my personal capacity today. One of the points that has been raised that I think deserves merit is that we lack the data to understand the composition of cases that are dealt with by the county courts across different court centres. And this makes it really difficult to compare performance between courts. We also lack good data to understand the workload of the judiciary and court staff. And if I may give one example, in 2020 there was a need to understand the split between civil and family work by district judges working in the county court, as there was concern that the understandable desire to make sure that people in care proceedings or with children matters were prioritised. But there was real concern by the civil judiciary that that was really impacting on delays on the civil side. At the time it was found that this wasn't recorded consistently, like what comprises a judicial sitting day, and is in fact the actual notion of a sitting day is recorded differently across different jurisdictions. Now, whilst I believe, and I'm sure if you put the question to them, HMCTS and MOJ would be happy to confirm this, that they are finally introducing guidance on standardised time recording, I think it's fair to ask why this has taken 4 years. It's fairly basic, because without this data it's impossible to understand and address the drivers of delay and manage resources effectively. It's the equivalent of trying to run a hospital without knowing what operations your surgeons are performing, whether you've got enough capacity to meet demand for different kinds of treatment. We wouldn't accept this in the private sector. We would not accept it in relation to any other public service, and we should not continue to accept it for our courts. The other issue that's often raised, and you've seen a line included in the Civil Justice Quarterly statistics now, is that the figures on delays are inaccurate because they don't take into account the issue of settlement. Now, I do understand why there's concern about this, but I am more concerned that we know so very little about the reasons why people settle or the amounts they settle for, because there's all the difference in the world between a case that settles because both parties have been supported to understand the merits of their case and have made an informed compromise, and cases that settle because delays have meant that one party, usually the weaker party or the more vulnerable one, has run out of resources, cannot afford to wait any longer, or is simply so brutalised and confused by the system that they just give up. The former is one possible outcome arriving from an effective civil justice system. The latter is a symptom of a system that is at best is failing and at worst is abusive to some of the most vulnerable people who rely on it to do better. So I think when we're talking about delays, there's a lot that's obscured by the fact that we have such, despite the amount that's been spent on digitising the courts and investments in data, we have such poor data to help us to robustly understand what's actually happening across the justice system.
Ministry, when the MOJ gave their evidence, they suggests that claims that go to full trial, and the distinction is made, the Master of the Rolls has made it, and others have made between, I suppose, those that settle, have, quotes, and he's going to quote, many user-driven factors that would determine timeliness that HMCTS has got no control over. Can anybody tell me what that means, the many user-driven factors?
It means nothing whatsoever.
No, I didn't know whether there was an intention to suggest that somehow people are intentionally dragging things out between themselves. That's certainly not my experience. My experience is people want resolution. Yeah. And if I could just pick up on the point about settlement and delay, one of the significant experiences of our members would be that parties settle because they've been waiting too long for their cases to be resolved. They turn up at court, they're in a block list, they're told by their barristers, you're probably not going to get heard today. And they can't afford to take another day off work, but they also can't cope with the emotional impact of the uncertainty of that as well. It's very, very stressful for lay people to go to court. even on matters that are, objectively not of great significance. They really do matter to the people involved, and the mental health impact of not getting your case resolved is significant.
Thanks. Yeah. And Emily, anything around the regional variations? Because you have a national body. We've heard there's the evidence from Matthew and others about regional variations.
Well, our geographical area, Chair, is quite significant. We kind of go as high as Peterborough. We're out into Kent, down as far as Southampton. We've seen instances, one of the major issues for us is when trials are vacated literally the day before due to lack of judiciary. That's happened 3 times in Plymouth recently. We also see significant delays within the courts in London and the South East. But on a point of as you rightly pointed out, that the county court is a national court. So when you bring a claim, you go onto the HMCTS website, and there's a function called Court Finder, and you put in the postcode for your your property, and but rather than you getting like one result, you often get several results. And so you're sitting there as someone who's litigating against, a social tenant, and you're thinking, well, we really would like this to be the nearest court to where that person lives, because they're going to be on limited means. They need to be able to get themselves to that hearing. And so you will then send the papers to that nearest court, because it's in that list, it's in that drop-down list. Sure. And then a few days later, you get those papers sent back to you saying to you, this is the wrong jurisdiction, can you please send it to another court? And there's no point in going back to them and saying you could have issued this and you could have transferred it over. And to be honest, if they had done that, we'd have probably lost the papers in transit anyway.
Does that happen much?
It does happen. It happens a lot. Yes. So, and again, it's that's the realities of it especially for our defendants in our matters, and also for our witnesses, especially in as I've mentioned before, our antisocial behaviour cases, and Elizabeth touched on it as well. You're asking witnesses to keep coming back. And things aren't being progressed, and things are going like part heard. The worst case example I have is a case that was issued in Chichester. We turned up for the first hearing, was told there was no judiciary available, it was going to be moved to Worthing. So the logistics of moving everybody to Worthing that same day was not going to happen, so the matter was then adjourned off again. And then when we all turn up at Worthing, we're told actually no, there's no judiciary available, it's going to be heard at Brighton instead. So our client officer is having to deal with some very distressed neighbours who have agreed to come forward and give evidence. And you're still looking at a case that's ongoing litigation. We're now 18 months down the line, and we're trying to resolve this matter. And that's what makes the impact for the delays on us in that respect.
Okay. Right. I'm going to bring in Mr. Chairman in quickly, and then Mr. Timpson. Yeah.
It's just really about the staffing as well, because of the reason that I suspect that problems are in the South East is because there's a high turnover of staff in the court service, some of them not very experienced, and obviously there's a huge reliance on temporary staff to do the work. So I just wondered what your thoughts were on that impacting, and also we've heard about the digitisation of issuing claims online now, but I'm not sure the back office stuff has caught up. The judges still use case management systems, which are like, case management is 30 years old and they still have to transcribe orders by hand. So I just wonder what your thoughts were on that causing delay, because I was shocked to see how long it takes to get some orders issued, which is just astonishing.
So, as I mentioned, before I became into a local housing association, I worked in local authority, which meant I worked in one court for over 10 years, and this is going back 13 years now. But during that period of time, you got to know the court staff incredibly well. You got to know the ushers, you got to know the listing clerk, you got to know the staff. All those people, very skilled, valuable, experienced people, have started to really significantly disappear, because now they're being replaced by agency staff, because there is not the remuneration or the morale there to kind of like keep people in place. And that's what becomes very frustrating when you're trying to progress matters and get things done. And it's like there was a recent piece by the writer and lawyer commentator David Allen Green, where he was sort of talking about the paper system being like something out of a Heath Robinson drawing, and, you know, the way things are moved around the courts, or at worst, you know, something out of Wallace and Gromit, the way, you know, this paper system. And I think I'd like to take another example of, like, if you've ever seen the film Indiana Jones and the Raiders of the Lost Ark, there's a bit at the end of it where the Ark has been put into a crate, and you see this person wheeling it into a storage facility, and then the camera pans back, and it gets bigger and bigger and bigger. That's what I think the court filing system is like. That's the impression that we get. There are mountains and mountains of paperwork, and in amongst it are our pleadings, are our applications, are our trial bundles, are our witness statements, which are very often missing when we turn up at their court, you know, to proceed with the hearings.
It's still paper-based?
Yes, yes, yes.
Perhaps, Emily, when you get a chance after this hearing, you might be able to find some statistics as to how often you find papers going missing in transit.
I think it's probably most hearings.
Hearings?
Yeah, we take duplications with us to now avoid that.
To avoid
that's
it.
standard.
Does that fit in with your experience as a practitioner?
So, as well as being a barrister, I sit as a deputy district judge.
Yes.
And it is, on a normal sitting day, there will be at least one file where papers are missing, and it will be more than that. It will be several files. It is a routine occurrence. And the knock-on consequence of that is that as the judge may make orders based on the paperwork that is in front of them, that order may be effectively wrong because they don't have full information. And the party then, on the receiving end of that order, has to make an application to have that order set aside. They have to pay a fee for the privilege of doing so. That requires another, hearing slot in front of a judge for someone to undo what has gone wrong. And that's all because the paperwork wasn't there to begin with.
A couple of quick ones and I'll move on to Mr.
I was
Timpson.
going to say quickly, I do think this is a problem of an analogue system in the digital age, and obviously one of the recommendations I'm sure we'd all make is a faster progress towards digitalising it and getting away from these vast Indiana Jones-style piles of paper would be a very, very good thing, and also a value-for-money thing and a good environmental thing as well. To the point about issuing, I mean, one of my members said to me the other day that with the new portals and so forth, you can issue very quickly, it takes 5 minutes. But on average, the letter telling you that the issue has happened takes 5 months to arrive, and it arrives in paper form. But can I say also about the postcode lottery, and I've got some statistics about average time taken to hear cases. Dartford, 829 days is the worst. Blackpool is the best at 79 days. And even that doesn't sound very good to me. I think part of the problem maybe, I'll be very careful what I say, is that judges may be expert in the law, but they may not necessarily be the best placed people to manage the courts themselves and manage the staff. There may need to be, from HMCTS, a very different approach in future to how they use their resource, and whether or not, indeed, more junior resource could be used for some of the things that are taking away the time that learned judges have to spend on them. I mean, there must be a better way and a better outcome than what we have here.
I wonder if I could just add one point, which is I think a significant factor in the delay in the system, it's got nothing to do with inexperienced court staff, but a simple fact that there are not enough judges to hear the cases. That's why everything is pulled due to lack of judicial availability. That is a euphemism for we do not have enough judges sitting to hear the number of cases that need to be disposed of. And that's the issue, because at the end of the day, there are administrative parts of the system that staff can deal with, but ultimately, at the end of the day, there are matters which are matters for the judiciary, and a judge needs to look over the file. And if there are not enough judges, which there are not, even when those judges are appointed, they are not given the opportunity to sit, and therefore capacity is lacking.
Anything else you want to add?
I think it's a source of considerable frustration to me, and no doubt to your members, that we are now 8 years on from the publication of the Transforming Justice vision for the courts. We have spent over £1 billion in that time. Only 24 out of the 44 projects that were meant to be in scope as part of the HMCTS digital reform programme have been marked as complete. But we don't have enough information from the court service to even be able to assess what actually does complete mean, whether we've developed, whether those projects have delivered fully against their original scope, because HMCTS hasn't recorded things fully. That is it is a catastrophically huge amount of money when we think about, all of the other things that we know about the justice system and the resourcing that it needs. And I'm afraid to say, and perhaps we'll come on to this later, that I think the county court has borne the brunt of the failure of the reform programme to deliver on its promise. And a lot of what you will have seen and a lot of what is observed here is the fact that we're dealing with these kind of far from end-to-end digitised systems. We're dealing with off-ramps and on-ramps and back into paper that just create these huge inefficiencies for people.
Okay, thanks. Mr Timson.
Thank you, Chair. Can I delve a little bit deeper into the functionality of the county court? And we've touched on, heard a very good example of why adjournments may take place, but they seem to be fairly endemic right across the county court system. For example, between November 2022 and March 2023, according to London Chambers, who did some research which you'll maybe be aware of, 372 cases, that was multi-track, fast-track and small claims, were vacated 3 days or less, or fewer, I think is the right word, before the trial. And in fact, 296 were just the day before. And you've already touched on judicial capacity, papers not being in order. What are the main other reasons that adjournments are happening at the last minute? And what do you think can be done about it to try and reduce them in the future? So, Elizabeth, you might be a good person to start.
Yeah, sure. So this may well, in fact, be my chambers. I can't remember. We did contribute some data. So it's possible that a hearing could be sort of cancelled at the last minute because the parties have settled and everybody's happy and that's the end of it. It could be because one of the witnesses is indisposed at the last moment, and of course nothing can be done about that. Other than those sorts of reasons, in my experience, and I would say the experience of members of my bar association, it is usually because of judicial unavailability, which is when the court will overlist in expectation that not every case will go ahead. And then what happens is, in fact, the cases stand up and there is therefore not enough time in the day for the judge to hear all of the matters that they have in front of them.
This is what you referred to earlier as block listing.
Block listing. Yeah. Now, some courts, despite overlisting, will still make you go to court. So if I could give an example, Bedford County Court routinely lists 10 or 12 fast-track trials in front of 2 district judges. A fast-track trial is usually at least half a day, often a day of court time.
They will be listed at 10 o'clock.
10 o'clock, so everybody turns up. If you've ever been to Bedford County Court, there are about 3 conference rooms, and I mean, I've sat on the stairs multiple times at Bedford County Court because there was nowhere else to sit. So if things are cancelled in a way that's frustrating, but at least that doesn't involve all the parties and the lawyers trekking off to court, waiting around all day, and that's when you get the situation where people settle, usually at undervalue, because they don't want to have to go through that again. So really these late adjournments, which then have a knock-on impact in terms of litigation costs as well, it's mostly, in my experience, due to the failings of the court system. And just to give an idea in terms of what the cost impact of that would be, from the perspective of the parties, by that point their lawyers are already engaged. So they owe their lawyers money, even if the case is cancelled the day before. So if you're an insurance company, for example, and your personal injury, road traffic accident matter is pulled the day before, you will still have to pay your lawyer out of your own pocket. If you're a claimant, so you're a real person, you'll be usually on a no-win, no-fee agreement with your lawyer. So it may be that you go to trial eventually and you lose and you therefore don't have to pay your lawyer. But the nature of the fixed cost system that we have in place to deal with lower value personal injury matters means that even if you win, and this rule is now being changed, but historically, even if you were successful, you would only recover 1 fee for your lawyer. So even though your lawyer had been engaged, let's say, twice, firstly when your case was cancelled, and secondly when it eventually got heard, and you would owe them twice, you would be only getting from the other side 1 fee to cover those expenses. So there's a knock-on impact, and really a complete lack of accountability from the sort of justice system side of things, a disregard and an expectation that this is just what you have to put up with if you choose to bring a claim in the civil courts.
Are there any listing strategies that you've seen in some courts which tackle this in a more constructive way. For instance, listing cases much earlier to try and filter out unmeritorious claims that may otherwise end up in the system for far too long. Ways of using the judicial capacity much more effectively and efficiently. Are there things that we should be looking at that you've, from a positive perspective, that would demonstrate that you can bear down on some of the pressure on the county court?
Not at all. I mean, I think one of the, it goes back to my basic point, is that we lack the data to understand, to do a proper time and motion study to understand how we might improve the way cases are listed, to essentially, and until we have that, until we're able to understand how long it takes for judges to hear a given type of case with different characteristics, it's very difficult to run the system as a system. And so we are then just, I could make some suggestions for you for things that we might do, but they wouldn't be based on anything other than instinct, which would make them no better than what we're doing at the moment.
Yeah, I think that's fair.
Could I just add as well, I mean, a lot of what we've heard put very eloquently reflects quite what an imbalance there is in the system between claimants and defendants, and the unattractiveness of actually going to court for a claimant. The delays, the cancellations and all the rest of it, it does make them much more prone to taking perhaps lowball settlement offers. So we have to ask, does this current very poor system benefit anyone? Yes, it does to an effect benefit defendants. And because we also operate in a lot of these cases in a fixed fee environment, that's two benefits really for the defendant. So there is an inequality of arms here that I think should be of considerable concern.
Is there anything within the civil procedure rules that could help both with that type of situation where claimants feel that there's sort of inbuilt bias through the delays within the system, or more generally around the timeliness? Because there are guidelines, but it seems in many cases, for instance, the 30 weeks between case management conference and trial just simply don't ever happen on a regular basis. Is there more that could be done in that respect?
I think that what does happen in some cases where claims are really over the time limits is they are given priority. And I think that is important and that's helpful, although by that point they've already had to wait far too long. I would agree that those time limits are not adhered to. They seem to be not really even an ambition, to be honest. I see cases taking much longer than that routinely.
Yeah. I mean, if I can add to that, obviously in terms of my area of work, we have a specific practice direction and a pre-action protocol for possession claims brought by social landlords. It's part 55 for possession claims. A lot of the timeframes within there are not adhered to, and it does, of course, make that very difficult for us. We used to be able to, in circumstances, say where properties had been taken over by trespassers or unauthorised occupants, something very separate from squatters. You used to be able to bring a case, and in my experience, you could actually get a case before a judge, and you could get possession. You could recover that property within 4 to 6 weeks. Now we're talking 4 to 6 months. It's just, yeah, a lot of the, when you read the practice direction, because that's the thing, you look to the practice direction to give you guidance, and then when it's falling very, very short, it will form part of a formal complaint, but it won't necessarily have any effect.
One of the changes that the government are bringing in is around mediation and the civil mediation service expansion to try and reduce delays in the county court, try and get settlements earlier. I think for small claims, typically sort of under £10,000, through this small claims mediation service. Is that going to have any impact? And if so, what is that impact, positive or negative?
Quickly, I mean, I think it is obviously mediation and indeed other forms of alternative dispute resolution have to be part of the solution here. There are areas of law, so lower value financial claims, also some family matters where the government is mandating mediation. It's anticipating a very large increase in the size of the mediation market, which I think we all hope it's capable of doing. There was a very good piece in the Times last week advising people how they might become a mediator. And I think it is, some of you might want to consider that in case things go wrong later this year. But it has to be part of the solution, but it's not the only part of it, I think. And we've seen in the past that some defendant organisations, insurers and others are sceptical about mediation because they see it as a layer of cost and not a way necessarily to reach actual resolution. So there are models that could address that. But also, they're not necessarily going to work as well. I mean, I think in family, which is not what we're here to discuss today, but if you're bringing together a couple who've made it very clear they no longer wish to be in the same room together, mandating that they do that might not really add anything much. So it has to be part of the solution, but only, I think, part of it.
In a personal injury context, as PI lawyers, we're quite good at settling claims when they can be settled, and we do so really without the need for a third party. The issue is that some claims just legitimately cannot be settled because there is a triable issue. There isn't a sort of compromise or a fudge that is palatable to the parties, and they're entitled to bring that dispute to court. So in a PI context, if something is getting to trial, then generally that's because it can't be settled and it needs to be resolved by a judge. Wearing my other hat when I do sit as a judge, I can see that mediation may be beneficial in other areas of law where there is scope for compromise, and particularly where individuals are unrepresented, so they're litigants in person, and they don't have that external perspective of a lawyer to say, come on here, can you see the wood for the trees? Bringing a third party in, I think, can be beneficial.
I could just give one other very quick example about arbitration or mediation, if I may. So when the government introduced the official injury claim portal for lower value road traffic accidents, its original proposal was to have mediation or arbitration as part of that, have an ADR function within it. They abandoned that because they felt there wasn't market capacity. And yet, of course, just a short period later, they're saying there is market capacity for all the things that we've mentioned. So I think it did miss a trick there. And perhaps we'd asked them to reconsider that. They haven't said they will so far, but I think it's a good opportunity to prime the market.
Doesn't this come back also to Lord Justice Briggs' proposals in 2015? Because as part of those proposals, the idea was that we would introduce an element of early neutral evaluation which would support litigants in person. The idea was that we would have a solutions explorer to help people understand what issues were at stake in their claim. And that, I think Lord Justice Briggs is on record as saying that was the main part of my recommendations. That was the one part of my recommendations, in fact, that would have expanded access to justice. Now, the fact that we're still, when was this first proposed? 2015. 9 years on. We haven't actually had an official statement from the government saying that they're going to abandon this, but we have seen in the change detected in the changes of tone in judicial speeches and in communications made by HMCTS, it appears they're kind of rowing back from their commitment to deliver this. And I think this is one of the big problems, isn't it? Where's the accountability for the things that were promised that have not yet been delivered?
Thank you. Mr. Chairman.
So just going back to the access to justice, and so this is particularly for Elizabeth, could you just tell us a bit more about the impact that you think the delays in the courts have had on access to justice? For the whole panel, about for both defendants and claimants, what your views are on the delays causing an impact on access to justice?
Yeah, I think, as I've already said, there's an issue with people settling at undervalue because they can't cope with the process anymore. And that's kind of individuals settling their claims at undervalue. But then I think it also works the other way, that commercial entities, insurance companies, for example, may just think, well, we'll just cut our losses and pay something, maybe even when the merits of the case are not so good. So yes, there's a resolution, but it's not a satisfactory resolution. And it's not really justice because it's not about what's right on the facts. It feels very often as though people are sort of having their arm twisted up their back.
And just to add again, my point about market confidence, in effect, the availability of professional representatives. I mean, we will see a shrinking of the availability of lawyers, or them choosing to do other areas, not going to lower value civil work, because they simply can't make a living out of it. And therefore, people have to either abandon claims altogether, despite them being very meritorious, or do it as litigants in person, or use lower quality professional support, which might not have the same outcome that they should, and again, lead to undersettlement. And again, possibly lead to further clogging and friction in the court system, which is not something that the judges want to see.
Can I ask, this is more about value for money, so obviously we've seen fees increase year on year, quite substantially. Do you think that the money raised through the court fees bears any relation to value for money for the court service?
No.
There's one point that this forms part of how we do our case management in my team.
Okay.
So obviously if you bring a claim, you sit there and you wait to get a notice of issue and then a notice of hearing, and we obviously experience the delays and we don't get those. So very often how we can determine if a claim has actually hit the court and has been dealt with is we go and look at the invoice that we receive for our PBA accounts, which are the accounts that we set up by direct debit so that the fees are taken. This is not an exaggeration. Usually the fee is taken out of our account at least 1 to 2 days after those papers have been filed at court. We then are waiting months before we actually get those notices of issue and notices of hearing. So if you're lucky, they might actually quote the claim number. So we know that a claim is now on foot. We can proceed with it. But if you are paying, say, £355 for a possession claim, you would kind of expect maybe if you were paying that amount of money for any other service to get quite a prompt response to that, not having to wait months and months and months for it.
And is that an issue with the CNBC, or is it more about sort of the HMCTS? Is it more about sort of the issuing and the papers being issued, or is it sort of further down the line?
I mean, I don't know how the individual courts are sort of like funded and if they have budgets and things, but it almost feels like that they've got to kind of keep the money coming in so that they can financially resource themselves in terms of, you know, maybe some of the basic recruiting staff, paying the staff, etc. It just seems to be, it's like we're putting the money in, but we aren't necessarily reflecting what we're acquiring in terms of what our output is. That's what it looks like from where we're sitting.
There was a parliamentary question asked recently about whether the increase in civil court fees would actually go into the civil court system, and it's a masterful bit of waffle, so you might want to see what was said there. The straightforward answer is no, it's not. The understanding HMCTS officials, and you may well wish to ask them this, is the money is going into the criminal courts.
Yeah, and this is the concern of PBA is understanding our personal injury cases, in fact, funding other areas of the civil justice system. And
they're quite open about it, aren't they?
The criminal justice system, yeah. And when we've tried to make those inquiries through freedom of information requests, we haven't been able to get an answer. Yeah.
And if things don't go right, you complain to HMCTS. Is that a point?
That gets you nowhere. There is literally, when my solicitors tell me frequently, there is no point trying to complain to HMCTS when, for example, additional costs have been incurred because of administrative errors in the court office, because they don't get their money back. And indeed, particularly where there's this issue about listing and whether it being a judicial function, and so the court office passed the buck to the judges, but then the judges will say, well, it's nothing to do with me. So there's no accountability. This is the issue. No one seems to take responsibility for the fact that the system doesn't work.
One of my colleagues at the moment, and again, this is the common theme from where we're sitting, is antisocial behaviour. So we've actually got to the point where we have got an order, and we want to enforce it. So, again, it's antisocial behaviour. It's continuing. The person that is perpetrating it is continuing to cause a problem. So we want to enforce it. We want to instruct bailiffs. We want to get our warrant of possession, and we want to go down that route. 6 months ago, the warrant request was filed at the court. She has had absolutely no response to any chasing emails and no response to two formal letters of complaint. Absolutely nothing. It's like, the rolling tumbleweeds response to that.
And how long was it before the M325 or whatever the form was submitted?
Basically, as soon as we were able to begin the enforcement of the order. So if it was, I don't know the actual details of the particular case, but say if it was a 14-day possession order, she would have put in that warrant request the day after.
And still waiting. And
still nothing. I mean, it's something that I refer to in the submission that I made. But another example is that we actually had an incident with a tenant who had various issues, including substance misuse, and we got our order. We'd actually sent off for the warrant. I'd actually been given notice of issue of the warrant, and then we received reports from the neighbours that this chap was having an episode and was pouring petrol around the communal areas and on himself and threatening to set fire himself, that obviously triggered a major incident. You contact that relevant bailiff's office and say, very serious incident has happened, please can we expedite this? And they're like, no, we can't, we haven't got anything availability for 4 months. Now, a warrant fee at the moment is what it was. It was 130, it's gone up to £143. So in that instance, we were like, right, well, we need to do something about this. So we make the decision that we're going to seek permission from the High Court to enforce it. So you've got the cost of the application fee, and then again, you've got to hope that the judicial boxwork is going to pick that up really quickly, and your covering letter will be like big, bold letters. This really requires a judge's urgent attention. You get your permission to transfer to the High Court. You then instruct one of the High Court enforcement companies to deal with it. So you're looking at, again, for a charity, for a social housing provider, putting an additional cost of over £1,000 to enforce an order that we should just be able to do normally. And that was, again, we have to take that decision because we want to protect the individual and the wider community. And that's we now kind of having to almost factor in that we are going to be spending that additional money because there just is, you know, the delays and the resources just aren't there for that those enforcement matters. And that's where the real worry is, that we can't enforce those orders once we've got them.
That's not a one-off, or that's a routine problem that I have heard cropping up repeatedly when it comes to enforcement, that the delays with the county court bailiffs are untenable. So I would agree and echo that.
Yeah, and just very quickly, is that a shortage of bailiffs, or is it just the applications on a mountain of paper somewhere?
I think it's both. I think it's things get caught in the paperwork, and it's also a shortage of bailiffs. And then also there was a bit of a shift, kind of like coming out of COVID. There was sort of like health and safety concerns, and again, it's kind of interesting that sometimes we'll get the county court bailiffs at the door, literally at the point of the eviction, suddenly saying that they're going to stand down, they're not going to enforce a warrant, and we'll often be, so, you know, we have to be there, and we'll be there with a locksmith, and we'll be there with the relevant officer. We'll even often be there with police officers, and a bailiff will suddenly turn around and say, no, I've got a health and safety issue with this, and they will pull back. High Court sheriffs don't seem to have that issue, but the county court bailiffs do. So, but that's maybe another conversation for another day.
Thanks very much, Mr. Chandler. Ms. Hopkins.
Thank you. So fundamentally, since the report back in 2015 about enforcement, my question was going to probe a bit more, but it hasn't improved at all. No. That's the sense I'm getting.
I think it's worth the committee looking at this again, because so essentially you had the report that described enforcement as the Achilles heel of the county court. Then, as part of the reform programme, plans to introduce significant reforms to the whole process were proposed. There was, I believe, in 2018, a 2-year contract for a supplier to deliver reforms to civil enforcement worth nearly £10 million, which was awarded to Solarius Consulting. And that was meant to do a whole range of things, not least including improving the information available to bailiffs and court staff, giving the courts and tribunals service visibility of previous interactions with claimants and defendants, and relevant information from other government departments to help them decide on next steps. The whole aim was to transform this service. But by 2019, the courts and tribunals service announced that they were suspending it as part of plans to try and remove £58 million from the cost of the court reform programme overall. And although there has been a blog from the Chief Exec of HMCTS saying we are still planning on doing something with enforcement, it's not quite clear what that something might be. And again, it's a source of real frustration, because what is the point in battling your way through all the other stages of the process to get this order if you then can't have it enforced? What is it that we're saying to people?
Absolutely. Thank you. Going back, reflecting on some of the staffing in the county court, and we touched on it earlier, it's around potentially increasing the number of salaried district judges, and appreciate, Ms Gallagher, you referred to yourself being a deputy district judge. Does the county court rely too much on deputy district judges? I'll take your views on some of that from all of you.
Yeah, sure. I mean, my experience as a deputy is that the courts could rely on us even more were it not for the financial constraints that are placed on them. So certainly we've just gone through a period between about Christmas and April when we were all itching to sit and we were just not being offered sitting days because there was no money. So I think it's possibly not really diagnosing the problem to say that the issue is part-time judges or fee-paid judges not being available. I think the issue is the money there to pay us in the first place? And I suppose there are, of course, advantages of having judges who are also in practice in terms of having that sort of finger on the pulse and really understanding the issues. But that's a slightly different question.
I'm not going to tell that to any full-time judges, I see.
I mean, I'm absolutely sure that that's right. I mean, I am really sympathetic to what the Lady Chief Justice has said, that she regards as the ideal split 80-20. But I think we need to look at, when you look at the Judicial Attitude Survey that was published for 2022, it's actually the salaried district judges who are the least happy with their working conditions, who are the least well supported, who feel under the most strain. And I think in those circumstances, it's really hard to say, oh, come and have this great career, because actually the reality is for lots of people within the system, that's not their experience of doing their work. They feel extremely committed to what they're being asked to do. I mean, I think it was quite interesting looking at the data from the Judicial Attitude Survey. 48% reported needing daily or weekly IT support, the highest of all judges. 40% said that the support that exists for them was poor or non-existent. 68% disagreed that the digital working that had been introduced is more efficient for them in terms of doing hearings, and 59% disagreed that it had been beneficial for their work. And when you're looking at things like that all contribute to kind of job satisfaction, how are we meant to resolve this problem, even if we pour more money into it?
Any other thoughts on the 80-20?
No, what I was just going to say about judicial recruitment. So in an exchange of letters with Lord Bellamy, I write a lot of letters to Lord Bellamy. I'm not sure how much he appreciates it, but you can ask him. But he said we're increasing capacity through judicial recruitment and are running recruitment campaigns to ensure vacancies are filled across the districts and circuit bench. I think it's troubling that they have to campaign to fill judicial roles. You would think that would be a highly desirable role, but it's obviously not the case. I think morale is at a low ebb, and I hear that again and again. It's not just from the judges, it's from all the staff. It's not helped by the facilities they have to work in. I think if people go to court and they see it shabby, none of the chairs match, there's not enough rooms to discuss things with your lawyers, it's bad enough if you go there for a day or two, but what if you work there? I mean, these are serious problems, which it'd be worth asking Lord Bellamy how he thinks his campaign is going.
100%, yeah. The county courts are falling down, quite literally. There is Romford County Court, the ceiling fell in the waiting room, and the court staff's answer to this problem, because how do you deal with a situation like this, was to block off that part of the waiting room. But when you had to walk through it to get to the courtroom, you were told to run. And that's but one example of a civil justice system that is literally crumbling, and that sets a tone, really, and it reflects what's going on in terms of the resourcing and the functioning of the system.
Elizabeth, something I picked up on was that the deputy district judges don't have access to caseman. Is that correct?
Yeah, so that's also an issue there in terms of how can you help fee-paid judges to be more efficient. That would be one way, would be to give us the same kind of access to systems that full-timers have.
And you preempted my next questioning around the state of the estate and that impact on safety as much as morale. I've got the sense that it has a negative impact. Anyone else want to add any further comments of their experience or what their members may say?
One thing to point out is that the 1.4 billion, or whatever the latest number is, modernisation programme. I mean, the NAO has done reports on this suggesting it's not worked well, it's been late and all the rest of it. This is despite the fact that I think just shy of 400 courts of various types have been closed since 1997. So over the last political generation or so. So this is a much, much smaller courts estate, which of course means individual consumers may have to go far further and find out that their sitting has actually been cancelled. But there we are. So, and it's patchy again. I mean, some courts, I believe Manchester is sparkling and new and very nice. There
really
we are.
Good, yeah.
But some of them, as we've just heard, are literally falling down.
I don't know whether we're going to touch on accessibility of court buildings as part of this. I won't say anything about that point yet.
Ask you about that in a moment. Anything else around the state of the estate. And you mentioned earlier about insufficient consultation rooms, for example. Is that something that is more likely than not that there's insufficient capacity if you want a private consultant?
Especially when you've got vulnerable witnesses, and again, say in an antisocial behaviour case, because if they don't want to see the defendant, you want to keep them separate. That can become a whole logistical juggling thing, and you're maybe even sitting them, say, outside of the court building in a nearby cafe or something, and then getting a phone call to kind of like bring them in, when it's time for the case to go ahead. But I mean, I think the other point in all of this as well is that sometimes this is for your ordinary person, inverted commas, this will be their only experience of going to court, and you turn up and that's what you're presented with. And it's supposed to be something that's, crucial to our democratic society. And you are walking into a courtroom and you're met with these appalling conditions. And yes, you've got the coat of arms up there, but, there's bits falling off and it's boiling hot and you can't get into the building if you're in a wheelchair.
Well, that's my next point of question. So I was shocked that there were, 10... county courts that are not accessible for wheelchair users, and it's across the country, whether that's Darlington to Hertford to Truro. Yep. What would you say to that? I think, is it all part of the terrible state of the estate?
It's scandalous. I mean, and this is just so in the PIBA submission, that's anecdotal. We've not gone round every single court and checked, but the idea that anybody who is disabled in this day and age wouldn't be able to get into a public building is something we should be ashamed of. But when you think about the fact that again, in a personal injury context, potentially the person is injured and can't get into the building for the resolution of their case about their injuries, it beggars belief. And I think it's particularly frustrating for us as a profession, as barristers, because we've been working very hard in recent years to improve diversity in our profession. And I know specifically of two chambers, barristers' chambers, whose barristers are part of PIBA, who are in the process of undergoing quite significant renovations to their building to make them accessible for their disabled trainees. And then you have these disabled trainees who can't go to court and do the work because they can't get into the building. And it just shouldn't. I can't even find the words to say how just this is just wrong.
If I could add something about vulnerability more generally, I mean, obviously this is a huge issue across public services and across the economy. So I made a freedom of information request recently to the Ministry of Justice, asking them. So Practice Direction 1A sets out a list of things that might count as a vulnerability, and I said, well, do you collect data on how many vulnerable people use the courts? And the answer I got was they do on an individual court basis, but it would cost too much money to collate that data to give a sense of how many vulnerable people use the courts. So once again, it's that situation where they don't know the size of the problem, they don't know the scale of the challenge they've got because they don't collect the right data, or if they do collect it, they collect it in the wrong way. This is just, I mean, Natalie's very strong on this point. There is a big data gap here that needs to be filled if we're to have the sort of courts structures and courts infrastructure that people need.
Thank you for that. And just a final point, is the County Court making sufficient use of remote hearings? Or what are your views on remote hearings?
So I think that we were really hopeful that some kind of positive lessons would be learned from COVID around remote hearings and when they can be used well. And certainly they don't work well with litigants in person who don't have lawyers, but where there are lawyers involved, particularly for sort of interim hearings and even some final hearings, they can be used really effectively. And again, anecdotally, what seems to have happened is that there's been a mood amongst the judiciary of let's just get everybody back to court. And so we're finding that hearings are not happening remotely when they could. And that's, it's not making effective use of technology, but also it's remote hearings can be a really helpful way to use time as well, everybody's time, to show respect for everybody's time, because you're not calling people to sit in a courtroom at 10 o'clock when they're not going to get heard until 3 o'clock, but you're offering that flexibility of, well, you know, your slot might be later in the day, or you have it might be between, let's say, 10 and 12 or something like that, and people are not having to go to the physical building, wait around, but it works better for everybody who's involved, and certainly it works well for professional users of the court system.
I think it comes back to also, if I may, so I led for the Civil Justice Council in the pandemic the first report that was looking at the impact of remote hearings on the civil justice system. And one of the key recommendations that we made to the court service was, in order to come out of this great experiment in remote hearings, understanding what the impact has been, you need to collect data to understand the impact on hearing duration. Because what you have is from a lot of professionals from the bar saying this is more efficient, this would make our lives easier, and then the lived experience from the judiciary who are doing those roles saying that we don't have the right IT infrastructure to support this, we think it makes hearings take longer, we think it's less efficient. Now, essentially, unless you have that objective data and you're able to demonstrate to people and reflect back to them whether or not hearings take longer when they're done remotely or not, you're going nowhere. It's talked a lot about, oh, it's been a great experiment. Well, it's only an experiment if you have an hypothesis and then collect the data to understand what the outcome has been. And I'm afraid in that fundamental respect, we have failed and we're still failing, and it's not good enough.
Thanks very much. Mr. Timpson.
Thank you, Chair. Can I take us back to one of our favourite topics, which is the reform programme? And I'll direct this principally at Natalie, but others are very keen to hear your views as well. We're now 8 years since its launch in 2016. A huge programme of $1 billion plus of taxpayers' money, with objectives, very worthy and much needed objectives around reducing pressure on the physical court estate, improving accessibility to justice, making the whole system much more efficient. It's now due to conclude in March next year. We'll wait and see. But what has, to date, the reform programme actually achieved, and how has it affected the work of the county court?
I mean, I think one of the, like I've said previously, one of the chief sadnesses about the reform programme is when it was first talked about, that it was the focus of the attention was very much directed at the county court and how we might use technology to improve efficiency and all of those things. And I think that the problem is actually many of the initiatives that were targeted initially at the county court have been scaled back and scoped back. So I've already touched on enforcement. That was withdrawn from the scope of the reform project. We've got to the point now where we're looking to the Ministry for Housing and Local Government to digitise the possession process. Originally, possession was in scope. It wasn't conducted as part of the reform programme. We're still hearing about the failure to just get the basics right in terms of IT infrastructure, Wi-Fi in the county courts. And again, the Lord Justice Briggs Solution Explorer, which is modelled on really successful initiatives in British Columbia, that just has failed to materialise. I think one of the big challenges with getting to grips with what the court reform programme has and hasn't delivered is the real lack of transparent communication about what was the original scope of what we were intending to deliver here, and then how does what has been put in place compare to that scope. That's something that the NAO has put up. I think it's a source of continual sadness because it was such a significant investment and actually such a huge opportunity to put in place the infrastructure that would set the system up to be able to be run like a system, and the fact that it hasn't materialised in that way is frankly quite devastating.
Is that a shared view?
Very much. So can I add something about modernisation, about the use of technology and portals? So we haven't yet mentioned the damages claims portal, which is introduced recently as effective like an online county court. And I think everyone agrees it's a very good idea, defendant, claimant, everyone's behind it. But it's not working in practice. It's having significant problems. It's adding to delays. And I think part of the reason for that is, again, they didn't understand the scope of it. It was perhaps rushed through. And I think what we see again and again with the MOJ and HMCTS is an inadequate engagement with the market, with stakeholders, to actually speak to practitioners and say, well, what do you think would work? How would we do it? And when things are rolled out, to have things like change control committees that can immediately look at problems when live cases go into them and resolve them quickly. There seems to be a sort of arrogance amongst officials. I think they know best. Well, they don't, because they don't have to use them day to day. So we are seeing good ideas failing in practice, at least on a short to medium term basis, because they're not making use of the expertise that's out there, and I think the shared willingness to make these things work.
Another, I don't know if this has been touched on or if the Chair and the members of the panel are aware of, but there is a possession claims online. You have MCOL and you have possession claims online, and that's used for routine rent matters by our in-house income team. And again, it's the whole point with any kind of IT system. It's dependent on how it's structured and how it's actually administered. The functionality of it should mean that once a claim is on foot, it's like you put in the claim details and it will generate your claim form and your particulars of claim. And then if you were to be using it as it is intended, you should be able to continue to electronically file your documentation, as you know, whether it's witness evidence applications, as you go through. And the orders and notices should be coming back in as well as anything that's coming in from the defence. That's not how it works in practice, because ultimately it's dependent on who's on the other end of that, inputting that information and inputting that data. So these systems exist, but they're not being utilised to their full effect, and there's no kind of sort of like joined up working, in terms of how these function and how these operate. So I think that's one of the biggest stumbling blocks in all of this. You're still ultimately having to go back to the people behind these systems, making sure that they're being administered effectively and used properly.
So is the answer to trying to prioritise what's now needed to make the functionality of this reform programme a reality about getting the basics right and speaking to practitioners, the users, those who are interfacing with the courts, as well as those who are trying to run them day to day, to establish what is holding the reform programme back? Is that the best use of what the resources that are left in the programme should be targeted towards?
I think it's really difficult, isn't it? Because we've got 120, depending, I think the National Audit Office reported that we've got £120 million left in scope of the original budget, which is a not insignificant amount of money, obviously, but it's not enough to do the things that are needed. And I think it's very difficult to think, having looked at what's really frustrating about this whole experience is, if you look at the Boston Consulting Group report that was produced for the reform programme in 2016, HMCTS and MOJ were warned about all of these issues up front. This wasn't a surprise. And the fact that they failed to heed those warnings or put in place effective kind of structure, governance and management to enable them to deliver this reform programme in the way that was needed. I just think it's incredibly frustrating, because it's not like these issues weren't consistently flagged. My secondment into HMCTS was designed to help improve stakeholder engagement, stakeholder management, the way that, the court service engaged with the expertise of people who worked in the system. And the fact that that didn't materialise, it's very difficult to look at what has happened and say anything other than like radical reform to the way we govern these systems is needed.
I think we might come on to that point in a moment. About 15 years ago, when I was last in sort of full-time practice, there was talk then about how we would no longer be bringing in sort of suitcases full of papers into the courtroom every day, and we'll be moving to this paperless existence. And here we are 15 years on, and as I'm about to probably go back into practice, I suspect I'll still be picking up bits of paper. How much longer are we going to have to wait until we have that paperless system that we see in other jurisdictions, including Singapore, where we went quite recently as a committee? Is this a pipe dream for me in my next stage of my career at the bar, or is this something that we can all look forward to in the next 5 years?
You could bring in rules to say that, for example, parties should only communicate with the court by email if they're represented, and just simply make it effectively legal to do that. I mean, there are ways you could achieve it. And I believe, Chairman may have recently visited the CNBC Centre in Northampton, and I think staggered, was the word I heard, about the sheer quantities of paper there, and the fact that there are teams employed full-time just to open the post. Again, this does not feel like a good use of resource. I think there may have to be more mandating of this, because perhaps paper is somehow a comfort zone for certain people. I don't know.
I think it's difficult, isn't it, with the digital exclusion point, because I am sympathetic to particularly if we're thinking about a system where it's harder for when more vulnerable people are representing themselves and may not have access to technology. But I think the problem is this failure to institute this end-to-end system means that we're relying on kind of manual workarounds for the points where the digital systems drop off, and it's just, it's just wholly inefficient. So very sadly, I suspect paper is going to be with us for a while to come.
I'll keep my supply of pens and pencils then. Unfortunately, at the National Civil Business Centre in Northampton, we didn't find the Ark. We did find out that there are claims that are being taken out of the digital system and being moved back into paper-based court system. Is this a phenomenon that others have come across? How widespread is it? And what issues is it creating?
When cases drop out of the damages claims portal, for example, that quite means they cease to be digital and become physical again, and that happens in a huge proportion of them. Absolutely. Adding to delays, adding to costs, friction, and the possibility of lost papers and all the rest of it. Yeah, it's incredibly hard, it seems, to make them do it. But I mean, that's why I said it should be compulsory, obviously, with the exception of those who, for certain vulnerabilities, it might not be. But if you're legally represented, you should be able to make sure your legal representatives are just operating digitally.
My concern, I think, is that it's fine to compel people who are legally represented to use online systems if you can be sure that those online systems are going to function properly, that the people working in the court office know how to use them, that the judiciary know how to use them, that everything is going to make its way to the judge for the day of the hearing. My concern, or my sense, is not so much that parties are wedded to paper and are therefore inundating the court with paperwork, but it is simply that the systems are not in place at the HMCTS side of things to really encourage a fully digital system. And if I could speak, as barristers, lots of us have gone paperless now, and we're turning up to court without any physical paperwork anymore. So as a profession, we are very keen on paperless working and looking for ways to develop that at our side of things.
There are some of the courts now, when you get your notice of hearing, that actually specify that they would like 3 days before the hearing, they would like a hearing bundle produced, an electronic hearing bundle. And they're always very, please, within 3 days before the hearing, will you file this hearing bundle? And you do, and you think it's marvellous, and you've spent time on Adobe Pro and you've made a lovely, fully searchable, proper electronic bundle, which I'm sure Elizabeth would really appreciate if she was instructed. But then again, you find yourself at the hearing, and because you will have told your instructed counsel and you will have told your client officer to take spare copies of the papers with them just in case. And that electronic bundle will have been disregarded because either maybe the member of the judiciary doesn't like them, or because that email has not made it onto the case management system so that it's available in the first instance to be looked at. So, like I said, there's all this technology and people's willingness to use it, but it's how you apply it and make it effective.
Or the file is too big. That seems to be a problem.
Yes.
And that seems a very easy one to overcome, you'd think, to increase limits.
Yeah,
not hard.
It's the lack of consistency across as well. That different courts will behave in different ways. So some of them are not remotely interested. If you try and send something, say, by egress, they say, well, we don't accept things by egress. So well, I'll put it into a protected document in Adobe Pro. Will you take that? No, we won't take that. And it's just, that would be a major help. And maybe, again, this is something to go back to, maybe amendments and reforms to the practice directions within the civil procedure rules, so that all these various eventualities now with technology are something that are actually, prescribed and set down, so that, again, all parties, claimant, defendant and the court know how they can actually, bring these cases into the courts.
Okay, thanks very much. Would you leave HMCTS as it is, or is there a fundamental problem with the setup of HMCTS itself? I mean, Natalie, you've been very critical of the leadership, the culture and the structure of HMCTS. And there is an argument that says it's not accountable adequately because it falls between two stools. It jointly reports to the executive, to MOJ and to judiciary, but neither of them really owns it. Nobody really owns the problem. Can you rely upon the current structure, or actually do we need to start again?
I am increasingly convinced that that's where the position that we're coming to. I mean, I think it's really important to recognise that the criticism of the structure is not an indictment of any one particular leader. They've had some really
it's not the individuals, but it's
not
the structure.
It's the structure. Yeah. And I mean, HMCTS has made some changes, most notably to its board, but given the record of delivery, I think it's difficult to argue that anything other than radical change at this point is needed. So one of the, and I think that is supported by numerous, including, this former senior president of tribunals, Sir Ernest Ryder, Dr. John Sarabji, who's former legal advisor to the LCJ, neither of whom are known for kind of hyperbole or... I think the problem is HMCTS formally operates as a partnership between the judiciary and government, but in practice and culture, greater weight is given to the priorities of the government and the judiciary. And this is partly because, the government is responsible for funding and administration of the courts and is accountable to Parliament for this, so sort of fair enough. But as such, the public description of HMCTS as a partnership has been described by some as a description that masks reality. And I think when you look at the issues that were engaged in the court reform programme, as early as sort of 2016, the Boston Consulting Group were flagging that the chief executive of HMCTS was spending upwards of 70% of their time in stakeholder management, which is not efficient in any sense. I think there's a huge issue as well in that under the current framework, the judiciary are under-resourced to deliver their leadership functions. They're forced to combine significant roles in management, in change management, in all of those things, with the work of judgecraft without proper management training and support and the structures that are available to the civil service. And I think also the kind of bifurcated structure, it really undermines coherent engagement with stakeholders, and this is one thing that I think has come out really strongly from all of us, that one of the things that could have really meaningfully impacted and made the reform programme better is if they got that communication right from the start. But I think the fact that often you're sort of scrabbling around to find out consistently what is actually happening, that is a function of the fact that it falls between two stools. On the question of, okay, so you're saying that we need significant reform, but what should we have in its place? I think if you look at international comparative research into court administration, there is a strong argument that a judicial-led system could increase innovation and improve transparency and accountability, but it would require significant change from what we have at present. So firstly, the judiciary need to be able to delegate decision-making in the way that ministers can to senior civil servants, because at the moment they're simply unable to. Essentially, what the system that we have at present means that the duties of leadership judges are basically carried out by a range of judges identified on the basis of their specific expertise or interest. I think when you went to the court centre that people have mentioned, you have a judge there, brilliant though he is, he's there half-time overseeing sort of 300, 400 staff. That is not a half-time role that you combine with something else. And I think the sort of net impact of what we have at present is that we've concentrated administrative decision-making in the hands of a small group of senior judges who aren't really supported to do that, and are trying to do that alongside other really complicated roles. They just need to be adequately resourced. The other thing that I think is really important is if we were to move towards a judicial-led system, we need to end the exemption of the judiciary from Freedom of Information Act legislation to ensure that we can properly scrutinise and hold accountable for the management and administration. Because I think one key lesson that comes from the reform programme is that many people, no one more than you, Chair, have tried to kind of get to grips with what is actually happening, what is being delivered. It's that failure of kind of accountability and transparency that has really led us to where we are, which is this huge catastrophic, what looks like waste of public funding at a time when we couldn't afford to waste it. So all of which is to say, I think it's very difficult to look at what's happened and say this is okay and we should just keep rolling on into the next thing. But actually making a break from the system that we have is going to require significant reform, and I guess the question is whether you've got a government that's willing to kind of prioritise unpicking Constitutional Reform Act and the Framework Agreement.
Also, I suppose the issue, in fairness, we looked at Singapore, for example, where they have what's called a ministry autonomous system, but essentially the judges are running it. They certainly have much more resource given to them to support it.
Yeah.
But also, you've got to have the willingness of the judges to do that. And I suppose I became a lawyer because I was interested in the law rather than being a manager.
Yeah.
And that creates a problem, perhaps, that we need to think about. And I suppose the other issue is where would you leave judicial independence? Because you make a fair point.
Well, I think you have...
You're accountable on the money side,
Yeah.
but how do you separate that out from your judicial function?
It is really hard, isn't it? And I think you have in Amsterdam and also in kind of the US, you have... I suppose the US is a different system again because judges are politically accountable in a different way. But I guess what it means is I think there needs to be, instead of this sort of fudge where it's described as a partnership but not really a partnership, if we say like we need to stop sort of, proceeding under this, I think what can be described as a fictional idea that they're jointly accountable and pick one of the two models.
Any other observations really on that?
Quickly from me, if I may, on HMCTS. I mean, when I've had meetings with them, I've asked if they have a strategy for dealing with the problem we're discussing today, which is delays in the county court. They seem surprised even to be asked that. To which the answer is no, they do not have a strategy, they don't have targets, they don't have data. It's chaos, frankly. Whether or not it needs to be completely restructured, I think that's a bigger question. What I'd like to see after the next election, regardless of its outcome, is a Civil Justice Commission being convened, which again brings together stakeholders right across the wider civil justice system to say, well, look, what other countries do well? What are the problems? How can we address it? Is it about money in a time of restrained public finances? No. Where do we bring in tech? Where do we have ADR? Where does legal expenses insurance come in? They're a big question to ask. But in the short term, with HMCTS, it has to be judged by the delays we're seeing. And just to come back to that, there are far fewer cases and they're taking far longer. That is administrative failure.
Okay. I won't ask the people who sit in the judiciary to make any observation on that one, but unless there's any other observation on that, it raises important issues. But I'm grateful to you all for your time and for your evidence today, which has been extremely helpful to us. So very grateful to all of you. Thanks for coming. The session is concluded, and all the very best, Natalie. Order.
The proceeding has ended. 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 The proceeding has